Good afternoon, ladies and gentlemen. I hope everybody's doing well. My name is Gerald Fenosi, and we are meeting again here today for part 3 of the legacy blueprint. Please, can I just get a thumbs up if everybody can hear me? Please let me know if you can hear me. Just a thumbs up, or if you can comment on the chat that you can hear me, so that we can proceed. Oh, good. All right. So welcome to those who are joining us for the first time today. Thank you so much for taking time out of your busy schedule to be with us. We are basically here to provide a legacy blueprint in order for you to properly plan your estate. Now, this is the third week, and today we will be dealing with the power of a valid will. The week before that, last week, we were dealing with estate planning tools, which were trusts. We were dealing with trusts, speaking about trusts, and the week before that, we were dealing with types of unions, which we will be recapping shortly. I just want to say a few words. This legacy blueprint is brought to you by Legiscore Legal Consultants and Advisors, which is the company that I'm currently working for, and in partnership with Retrosebenza, which is a company which is based in Lefere, as well as Rosquart. They are NPO from Lefere. So they are basically doing community development in the area. They're bringing in opportunities for the youth, and they're also doing capacity building for the SMEs as well. So just want to shout out to them for partnering with us in this initiative to ensure that we give you this vital information as a member of the community. Okay, so I'm just going to ask us to just wait 2 more minutes. There are probably some people still getting online. Can I just have 2 minutes of your time? You can just wait 2 minutes and then we will start. Thank you so much. So thank you so much for your patience. We will now start our presentation for today. So like I said before, today we are going to discuss wills. We are going to discuss the proper way of drafting wills. We're going to discuss the legal requirements of a will and everything surrounding that. So I'm just going to ask us to briefly welcome you to the Legacy Blueprint. As I said before, the Legacy Blueprint is a series of presentations that are dedicated to ensure that you have enough information to properly plan your legacy, from the type of marriage union, as well as marriage regime you choose, to the type of trust you open, and to the type of proper will that you construct. These are the type of things that we are looking at. And all of these things play a vital role in ensuring that you have a properly planned estate. Should something happen to you, your affairs should be in order. So this series is dedicated to ensure that you get that type of information so that you can be empowered to make educated decisions. Right. So welcome to the legacy blueprint. This is part 3. For those who have missed part 1 and part 2, I encourage you to go on YouTube, Gerald Kenosi, under my channel, Gerald Kenosi, and then you can see part 1 and part 2. Very important, especially the one from last week, as you know, trusts are very tricky. A lot of people do not understand. Trust, not necessarily a legal person, and then at the same time, they do have a trace of being a legal person. It's just a bit of a confusion there. So I advise you to go and check out that video on YouTube. All right, so now what we're going to cover today is the following. We're going to understand what the will is. We're going to understand why the will matters. We're going to discuss the requirements of a will, the legal requirements of a will. We are going to discuss the invalid formats of, how the type of formats that you can't use to write a will. Okay, we're going to make your will uncontestable as well. That is very important to make sure that once you have written your will, when you do pass away, those who are left behind cannot contest the will because there are certain requirements that need to be met. Your marital regime, how it affects your will, we will discuss that in community of property, out of community of property. What happens when you die with a will, without a will, those types of things we're going to cover. We're going to cover the critical role of life partners. We're going to cover what happens when you have a girlfriend and boyfriend, partner and set. What happens when you die in that type of situation. We're going to discuss that as well, with or without a will. Okay, and the last one, we're going to discuss the consequences of dying without a will. So we're going to cover all those things today. Should anybody have any questions, I would recommend that after each section, please kindly raise your hand. Once I'm done with the section, then you can ask a question. Either we'll open up your mic or you can simply type in the comments, in the chat. All right. Okay, so we're going to recap part 1. Just quickly, I'm going to go through them quickly because these are what we covered in the first week of the legacy blueprint. So in part 1, we covered the types of marriage unions in South Africa, or type of unions rather. The civil marriage, which is the traditional one, man and wife. You can get married in community of property, out of community of property, with or without accrual. Okay, we have civil unions. This is a type of union that is created for same-sex marriages. Lesbians, gays, they can get married through this type of union in South Africa. However, also heterosexuals can get married through this. So opposite or same sex can get married through this. It's essentially the same as a civil marriage, just that it allows for same-sex partners to get married. Now, we also have customary marriages. This is a type of marriage union that allows a man to have more than one wife. A man could still have one wife, but it allows a man to have more than one wife. Okay, so we discussed the requirements, which means that the first requirement is that there has to be some sort of customs that are observed. So in this situation, it means that the man must take out the wallah for the woman, and the uncles and the family, they must meet, and after that has happened, there will be some sort of a ceremony, and that is basically customs observed. The second requirement is that the people need to be, two of them need to be above 18 years of age. If they are under 18 years of age, they need consent from their guardians or their parents. And the most important is that there needs to be consent, right? There needs to be consent between the parties. And they have to be competent to be married to one another. We're going to get into that now as to what do I mean when I say they need to be competent. Okay. Now, in life partnerships, we discussed that should you pass away with a girlfriend or a boyfriend, you do not get any sort of automatic benefits of a wife or of a husband. You need to get into a universal partnership agreement. It needs to be written down. There is also a tacit one whereby you show through your actions, but however, that is difficult to prove. So I did advise that rather have an express contract, universal contract that says, this is my life partner, I'm going to share my life with this person, we are going to share things between ourselves. Then you actually add on top of that, you add a will to solidify your partnerships, so that should something happen to you, whatever it is that you have goes to your partner. to your life partner, right? So general principles for all unions. Remember when I spoke about competency, that you need to be competent to marry that person. There is what you call prohibited degrees of kinship. So this means that the law prevents you from marrying people, especially who are too closely related to you. For instance, your brother, your sister, your mother, your father, your grandfather. You can't marry your, your auntie. Those people are too close to you. But however, they do permit that you marry your cousin, you marry your sister-in-law, your brother-in-law. But you cannot marry your wife's child. You cannot marry your wife's mother or your husband's father or however it is. It's all about how close the people are to you. But those are what we covered. If you want to know more about that, we covered it extensively in the first part. You can check that out on YouTube as well. And understanding these types of unions is very important because essentially it is the foundation of your estate planning. Which types of marriage unions that you choose will also have an impact on your estate planning. So it's important to know that you have chosen the right union first, and then you've also chosen the right marriage regime. All right. Okay, so that was part one. Now, part two, we spoke about trusts last week. This one is a little bit of a complicated one, so I'm just going to try and go through as quick as possible, but to make you understand as well. What is a trust? It is a legal arrangement where assets are held by a trustee for the benefit of the beneficiaries. That's what we spoke about last week. Like I said, a trust is not a legal person, but however, for certain situations, it can be recognized as a legal person. In certain situations, like for tax purposes, as well as in cases of insolvency. Correct. So, yeah, I'm going to get into that. Now, there are three parties that are involved in a trust. There's a founder, there's a trustee, and then there's also a beneficiary. We spoke about that, right? We spoke about the types of trusts. There's a testamentary trust, and then there's an inter vivos trust. Testamentary trust is what you open. Well, you can't really open it, but once you pass away and you have written in your will that you want to open a trust, that's the only way a testamentary trust can open upon your death. So it gets opened through a will. That's the only way you can open a testamentary trust. Now, an inter vivos trust is a living trust, which means you open it while you are alive, and you need a trust deed. A trust deed is essentially an instruction that says how you want your trust to be governed. You understand? That's what we covered last week. There's more of that, like I said, with part one as well. Part two is on YouTube. You can go and check that out as well for more information. And then we also covered trustees' responsibilities, that they have a fiduciary duty. A trustee holds an office, it's an official office. So in other words, they need to get paid as well. And they are also bound by rules. So trustee cannot do as they please with the assets that are within the trust. I made an example last week that picture a trust as though it is a box, right? I'm going to use this an example because it's the easiest one, like a toy box, right? And in that box, there are toys. Those toys are the assets that the founder puts into the box, right? Now, the trustee is the one that has the lock to that box. So they unlock, they take out, they open the box, they take out the toys and they give it to the children. Now, the children in this case are the beneficiaries. So the trustee handles and manages the assets for the benefit of the children, which are the beneficiaries. That's basically how a trust operates. Okay, avoiding abuse. The trustee needs to get a letter of authority from the Master of the High Court before they do anything. They need to be recognized in their office. They need to be provided with the authority to do certain things. They can't just act. Anything that they do without the authority from the master, it's going to be invalid or null and void. All right. Key benefits. The reason why you would open up a trust is to manage your assets and for protection as well, to prevent disputes, to prevent families from fighting over the asset that you have left behind. Estate duty and tax planning. So just to briefly explain, estate duty tax is what you get charged when your estate is being wound down, the tax that gets deducted from that. So since your things are in a trust, they don't belong to you necessarily. When you pass away, you don't get charged that specific tax. So you do get to save on that. Now, there's also flexibility and control. Essentially means that you can do whatever it is, or you can decide on whichever way that you want your trust to, to operate. So in other words, a trust, you can compare it to a will, which is what we're going to cover today. You have freedom to decide what you want to do with your assets in a trust in the same light as you have in a will, right? Efficient administration, streamlining asset transfer outside the estate winding up process. So when you pass away, your estate, your property, especially if you own a house or anything like that, the people who are left behind do not have to pay transfer fees. They do not have to get attorneys to transfer specific property into whoever it is that specific property was left for. They don't have to transfer it into their name because it's already in a trust. It belongs to a trust. The trust offer advanced strategies for asset protection and ensuring long-term beneficiary well-being. So this is what you use if you want to have generational wealth, essentially, a trust. So now I'm really passing through it because we have a lot to get through today. But should anybody have any questions about part 1 or part 2, please kindly raise your hand quickly. Let me just try and tackle them. Is there anyone? There's no one. Okay, that's fine. If you have a question, if you are too shy or something to ask, please note it down or throw it in the chat. I will be able to answer them after this section that we're about to do now. So introduction to wills and estates. In this presentation, we will explore the critical aspects of wills and intestate succession, emphasizing why having a clear plan is essential for safeguarding your legacy. This is basically what the entire presentation is about, telling you the importance of a will, what's going to happen if you don't have a will and you pass away. So we are just trying to avoid those types of situations whereby people are fighting for your things after you pass away, right? So what is a will? I'm going to open up the floor. Does anybody have an idea what a will is? Can somebody just give us an answer? Does anybody have an answer for me as to what is their understanding of what a will is? By the way, for those who are on TikTok, because we are streaming live now, you can join us on Teams directly. All you need to do is to search for Gerald Kinosi on Facebook. I have posted the link. So you can just quickly register and be part of the actual presentation. So please, if you would like to get your questions to be answered, please go on to Gerald Kinosi on Facebook and click on the link and be part of the meeting. All right. So if does anybody have a question? Can anybody explain to me what a will is? No. Okay. All right. So I'm just going to briefly explain what it is. A will is a critical written document where you, as the testator, express your voluntary wishes regarding how your estate should be distributed after your death. So the will is similar to a trust in that it is a document that expresses how you want your assets to be distributed to whom, how, and when. So you have freedom of testation. That's what it means. When you pass away with a will, you pass away testate. It means that you have freedom of testation. When you don't have a will, you are intestate. Okay, we will get into that and explain the differences between the two. Now, it's a unilateral act. This essentially means that you are the one to decide what you want to happen to your things. When you write a will, your express wishes, your wishes need to be followed, you need to be written down. So somebody cannot assist you to write a will, especially if it's somebody who is going to benefit from the will. It has to be done by you. If there is somebody who is assisting you, it can be a legal practitioner, a person who is experienced in writing wills. They will be the ones that can assist you to write your will, provided they are not going to benefit from the will. We will explain that later. Okay. So the primary purpose of a will is to ensure your assets are distributing according to your desires. So it's freedom of testation, like I said before. You must comply with certain legal requirements for it to be considered a valid will. We're going to be getting into those now. So what is an estate? An estate is the total sum of your assets and liabilities that you leave behind when you do pass away. That is your estate. So when we say estate planning, it means a combined sum of your assets and liabilities. That's basically what your estate is. So when you properly plan your estate, you are ensuring that your estate will benefit those that come after you. You understand? That's what a trust is for. Hence, is a trustee and they are beneficiaries of their trust. The law of succession determines how this deceased estate is managed and distributed among your beneficiaries. Okay? The law of succession. So now, when you pass away without a will, your estate will be distributed according to the Intestate Succession Act, which means that the state gets to decide who gets what. Unlike when you pass away with the will, then your will is the one that's going to govern how you want your things to be distributed. Right? So why have a will? Can somebody just answer that for me? Why must we have a will? Now you know what a will is. Tell me, why must you have a will? Why is it important to have a will? Is there anybody that can answer me? There's no wrong or right answer, by the way. So just give me whatever it is that you can give me. You can type in the chat, or you can ask for raise up your hand and ask for your mic to be unmuted. Anybody? There's no one. Okay. I think I might start picking some people now. I might pick someone, but we'll let this one slide. Okay, like I said before, when you have a will, you have freedom of testation. That means you get to decide who inherits, what they inherit, and how they inherit it. That is very important. So you can decide who benefits. It can be a company, it can be a charity, whoever it is that you see fit. Whether it's a natural person or like a normal individual or a juristic person, which could be like a company or any other organization. What they inherit, you specify. You need to specify which items. I am leaving my car to Sibongile when she turns 18. So you can also have conditions when you're writing a will. You don't just write and say Sibongile gets the car. You can say maybe she gets the car after she finishes her first degree. You can also do that. Right. So you have freedom of testation, and nobody can contest it. Hence, we are going to give you the proper tools so that when you write your will, it cannot be contested. Right. This is just to emphasize that without a will, your estate will be distributed according to the Intestate Succession Act. This means that the law decides who gets what, which might not align with your wishes. Hence, we just emphasize the importance of having a will. Now, this is very important. I need you guys to pay careful attention to this one. These are the legal requirements of a valid will. If any of these are not met, your will not be valid and it will be easily contested. Okay, your will be null and void if the following requirements are not met. The first one, you must be at least 16 years old to write a will. So if you are 16 and above, you can write a will. You must be of sound mind and capable of understanding the nature and effect of making a will at the time that you sign it. So this obviously means that people who are who do not have the mental capacity, whether it's mental illness, dementia, whatever it is that it could be, they cannot write a will because they are not of sound mind and do not have the capacity to make a decision or to understand the effect of writing a will. So you need to be of sound mind when you are writing a will. It must be a voluntary expression of your wishes. That is a very important one. Hence, I'm saying when you write a will, you need to be alone. Does it make sense? You need to be alone when you are writing a will, unless it's paired with the legal practitioner. So that is testamentary capacity. Now, these are the legal requirements and formalities. These need to be present, otherwise your will will be null and void. The first one is that it needs to be a written document. It doesn't matter whether you type it, but you need to print it. It needs to be a physical document. The reason being it needs to be a physical document, there needs to be a signature by the testator. The testator needs to physically sign it. It cannot be a digital signature. It has to be a physical signature. All right. Now, your initials qualify as a signature as well because a lot of people, they struggle to sign. If you are using a mark like an X, or if you can't sign, you're going to get somebody which is called a amanuensis. No, amanuensis. That word always gets to me. But essentially, it is somebody who signs on your behalf. In this situation, you need to go to a police station and it needs to get signed in front of a commissioner of oath so that it can be regarded or it can be acknowledged that indeed it was signed by you, even though somebody used their hand to do it. But it does count as your signature in that situation. All right, but it needs to be signed by the testator. Okay. Another important point is that there needs to be two witnesses. These with two or more, but it needs to be two or more. So it cannot be two or less. It can't be one. It needs to be two or more. Okay. These witnesses need to sign as witnesses on the will. They don't need to see the contents of the will. Remember, the will is your wishes. If it means that you're the only one that's going to know what's inside the will, then so be it. But, however, the witnesses need to be present. They need to sign the document to ensure that they did indeed see that you did write a will. That is why it is important. Okay. So, yeah, those are the three. It needs to be a written document, it needs to be signed by the testator, and there needs to be two or more witnesses to testify that indeed there is a will. Now, they don't need to know the contents of the will, but it does need to be signed by them. Even if you could say, hey, this is the will, please sign there as a witness. Okay. So, are we all together? Does everybody understand, or does somebody have a question so far? Okay, yes. Okay. Right, so there are no questions. Let's move on. This is another important point that we have to make. How to make your will uncontestable. Let's get into that one. Now, obviously, we can't 100% guarantee that it can be uncontestable 100%. But following these guidelines, we will increase the probability of it becoming uncontestable. Because at the end of the day, remember, everything in South Africa needs to, any dispute that goes in front of the court, the outcome cannot be guaranteed. But if you follow the following steps, it's going to reduce the chances of it being contested in the first place. Okay, so you need to have a clear a will. It needs to be clear. So whatever it is that you want in the will needs to be clear. When a person reads a will, they must not ask themselves more questions like, but what did they mean when they said this? It needs to be clear. When you say, I want to leave this car to my daughter, if you want to give them, maybe name them, I'm leaving this car to Simpiwe when she turns 18 and when, or perhaps when she finishes her first degree. It must be clear. Be clear. If by any chance, maybe English is not your best language, write it in your home language, it's fine. As long as it is clear, your intentions are known. And try to stay away from complex words. Do not try to sound like a lawyer. Make it as simple as possible. To help you, write it as though you are writing to a 10-year-old or a 5-year-old. Make it that simple. That is important because you need to make sure that it is clear. The formalities, make sure that those 3 formalities are met. It needs to be a written document, it needs to be signed by a testator, and there needs to be 2 witnesses. Please make sure that that is followed. And your intention, again, you need to clarify, you need to make sure that everything is clear. Your intentions must be known. Okay, you cannot speak half-half. You need to make sure that the will is understood. Read it twice, 3 times, over and over. Make sure that what you have written down makes sense to you. Because the person that's going to be reading that specific will does not know what is happening inside your head at the time. So you need to make sure that people understand what is happening. Okay. Right. This is another important point. Avoid delegation. When you are writing your will, make sure that you are doing it by yourself. It is a unilateral act. Do not ask somebody to assist you to do it. It's not going to, in a way, it is a security risk for you, for somebody to know what is in the will. Because I don't want to get into too much information, but we've seen in a lot of instances when perhaps the husband knows what's inside the wife's will, if maybe that person does not have the right intentions, they might even end up doing something to the wife in order for the will to be actioned sooner. You understand? So it's very important for the contents of the will to be kept to yourself. The people just need to know that there is a will. They don't need to open the envelope until you pass away. A lot of people do wills through law firms. The law firms keep the wills until the passing of the individual. All right. So that's basically how it's done. Same thing with the banks. The banks keep the will. Once you pass away, then the will gets executed by the bank. All right. That's how closely guarded it must be. So also, you need to ensure that you have a regular review. Life changes. You might have a new granddaughter, grandchild. Make sure that you update your will. Every time something big happens in your life, make sure that you update your will in order for it to stay updated. Now, what's going to happen is that the previous will will be, what is the word I'm looking for? The previous will no longer be valid. So this new will essentially, what's the word I'm looking for? Well, the new will be the one that is valid. The old one will be invalidated by the new will. Am I making sense when I say that? So you just need to make sure that you have regular reviews of your will as and when life changes. Okay, are there any questions so far? I need you guys to stay with me because everything builds on top of everything. Okay, one step builds on top of the next step. So we are moving slowly. So I need you guys to ask questions when you get lost. You have questions? Do you have any questions, Kutwano? You guys have any questions? Come on, don't be scared to ask. No questions. Are you guys sure? All right, so we're good to go. Let's move on. So now we're going to, this is a very important part. It's actually one of the requirements. Remember when I said 2 witnesses need to sign the will as witnesses. Now we're going to ask ourselves, who can be a witness? A competent witness. It's any person who is aged 14 years or older who is capable of giving evidence in a court of law is a competent witness. Now, one might ask, why is it that you need to be 16 to sign, to write a will, but 14 to be a witness? I guess that's just how the law is, right? Like they are saying, you need to be competent to give evidence in a court of law, and you can do so by 14 and above, right? So disqualification to prevent fraud. Any person who attests and signs a will as a witness cannot be a beneficiary of the witness. That is a very serious point. You need to make sure that if you are benefiting, you cannot be a witness to that will, because you will forfeit whatever it is you're supposed to get in that will. You know why? Because remember when I said a will is a unilateral act. If you sign as a witness, it will seem as though you were the one helping the testator write the will, and that counts as undue influence. And that is a matter that can be contested in court. So the will can be contested in such a case. The person who signs as a witness and is a beneficiary to the will forfeit their portion. Okay. It's obviously not guaranteed. It is a high possibility that it will happen. Like I said, everything gets dealt with in the court of law. So we just need to be careful with that part. All right. Now, this is a very important one. A lot of people do not know this part. I wanted to touch on this specifically because a lot of people think that certain formats are okay as a will, but they're actually not. So we're going to get into that now. An oral will does not count. It cannot suffice. It won't be executed as a will. Remember, one of the requirements are not there, which is it needs to be a written document. It has to be a written document. It has to be a physical document, right? So an oral will cannot, it's not good enough because it doesn't qualify as a document. Am I making sense? You cannot have a video or a voice recording as a will. Like I said again, because the requirements are missing. It needs to be signed by a testator, it needs to be 2 witnesses. So how do you get all that if it is a video? You understand? Something needs to be written down, there needs to be physical signatures. Electronic formats, you can't have a will and store it up on the cloud, unless maybe it's a copy of the will, but again, you need to have the original will. The original will is the one that gets executed. All right. So am I making sense so far? Does anybody have any questions regarding that? So all of these, they cannot be classified as valid wills. Okay, you cannot record yourself. You understand? So does anybody have any questions? By the way, I forgot to introduce Tsedimoso Sopona is our moderator. So anytime I'm looking this way and I'm communicating with someone, it's our moderator. She's the one that's taking your questions and everything else. All right. So please do not hesitate. Write down your questions. Put up your hand if you want to ask a question. We'll unmute your mic. Does anybody have any questions so far? Any questions? No questions. Okay. So now we are getting into the serious parts. This one goes hand in hand with part 1, types of unions. Okay. This one, what happens when somebody dies with a will? Going to get into that now, and please pay careful attention to this because it is going to get a bit complex, right? Okay, when you have a will, it guides the distribution of your deceased estate. However, your marital property regime still plays a crucial role in determining what exactly forms part of your deceased estate. Okay, that is just something for you to keep at the back of your head. Now, what happens when somebody dies with a will and they are married in community of property? So what's going to happen is that in a marriage of community of property, you do understand that it's two estates that come into one single joint estate, right? And the only time that these estates are broken up is through dissolution. It's either through divorce or through when somebody passes away. That's the only time that an estate gets split into two, when two people are married in community of property. So upon death, one spouse keeps their 50% and the other one gets distributed according to the will of the spouse. This is when you pass away with a will. Okay, so that spouse, the surviving spouse will get their 50, and the spouse who has passed away, their assets, their estate will be distributed according to what they have written down in their will. Does that make sense? And that is basically what happened. That's basically what's going to happen. One spouse keeps 50%, the other one according to their will. If this one wants to give everything to Mokapenwake, that's what's going to happen. All right, it can't be contested. Hence your freedom of testation. All right. Okay, when you are married out of community of property, similar thing happens. But now, remember, out of community of property without accrual, it means what's yours is yours, what's mine is mine. When you pass away, each one keeps their own share. So this spouse who passed away with a will decide what happens to their estate when they pass away. The wife will have no automatic access to the spouse's assets because it is a separated estate. There is nothing that combines their estate. Even their debts are not combined into one when they get married in community, out of community of property without accrual. That's basically what happens. Right? There is no sharing or calculation of accrual between your estates. We are going to get into out of community of property with accrual in a moment. What happens when people are married? Is there a question?
Question, okay.
Okay, Temo, okay, go ahead. Temo?
Okay. Number one, already. What is your opinion with the will handled by the commercial banks versus a legal firm, and why prefer one over the other?
Okay, so the question of Temo is my opinion on when banks handle wills and when law firms handle wills. Essentially, that question I can't really 100% answer it because I don't want to get sued. But what I'm going to say is, in my personal opinion, now let me personalize this because I don't want to be misunderstood. I personally would rather go for a law firm, right? I would go for a law firm on the basis that the law firm is sort of easier to get to, unlike the bigger institutions. I think they are a little bit intimidating and stuff like that. But I would just need to do it through a law firm. Now, there's a possibility that law firms could be cheaper. I don't know. I'm not saying anything. There's a possibility they could be much cheaper than the other institutions in terms of executing your will. So I suggest that you try and do your own research when it comes to that. Okay, I don't want to say things and unfortunately it gets me into trouble, right? But nonetheless, please do your research. I personally prefer to do it through a law firm. Okay, have I answered you? You said two questions. What's your other question, Bill?
What is a downfall, a negative of a will?
What is a downfall or a negative of a will? I would say there isn't one. Because remember, a will is what you want to happen to your assets when you pass away. I feel like there's no better gift than that. If we don't have a will, that's where there are going to be downfalls, and we're going to get into that. You'll understand why. But there is no negative thing that I could say about having a will, because essentially it's your will. What do you want to happen to your things when you pass away? And it also ensures that your children are safe, because we see, ladies and gentlemen, what's happening lately in this world. When, let's say, for instance, there is a brother who dies, he leaves a surviving wife and children, and then that person's brothers or sisters come and feel as though they are entitled to their assets and take those away from the surviving spouse and the children. Now, this will ensure that that doesn't happen, because immediately when you pass away, your will gets executed. If you want a specific thing to go to your children, it goes to your children. But again, if you're married in community of property, half of it already belongs to your wife. And if you don't write a will, it's going to open up a can of worms in a way. So I would say a will is the best thing you can do to ensure that you plan your estate. There isn't a negative thing that I could say about it. Hope I've answered you, Debo. Thank you so much for your question. First question of the day. Second question, actually, yeah. But anybody who has any more questions? There are no questions. Okay, so let's get into this section now. You are married out of community of property with accrual. Okay, so what is going to happen is that what's yours is yours, what's mine is mine. But the growth of our estate while we are in the marriage, that is what you call accrual. That is what is going to get split according to calculations before the estate is split into two. Right? So when you get married out of community, like I said before, what's yours is yours, what's mine is mine. But the growth of the estate between the two of us during our marriage, that's what gets split into two. You understand? So upon dissolution of the marriage, the calculation is done to determine the accrual claim. The spouse with the smaller growth in the estate has monetary claim against the estate of the spouse with the larger growth. I'm going to explain the calculation shortly. Okay, let me just explain it now. So for instance, you are married to your wife, right, out of community or property with accrual. What's going to happen is that during the course of your marriage, your estate has grown by R1,000,000. Your wife's estate has grown by 200,000 rand. What's going to happen is that you have to take the amount of the lower growth, minus it with the higher growth. So it's going to be R1,000,000 minus 200,000, which is going to be 800,000. Now the calculation is that the one with the lower growth gets half of that difference. So in this case, half of 800,000 is 400,000. So the wife will be entitled to 400,000 of the husband's growth accrual upon dissolution, whether it's divorce or death. Once that is done, it means that the accrual is now split, the estates are split into two, then only can the deceased spouse have their assets distributed according to what is written in their will. Is everybody with me? So the spouse with a higher growth in their estate, the one with the lower growth minuses their amount from the spouse with the higher growth amount, and the lower growth spouse gets half of that difference. So in this scenario, I think this is actually a perfect scenario. It shows that both of them are going to get 600,000 in this case, even though the one only gets 400,000, but now it sort of levels the playing field. Does it make sense? Okay, are there any questions? Everyone's good. Okay, so I'm going to move on then. Please, if you have any more questions, if I'm moving too far, please type them in the chat and we will get back to them afterwards. So now we get into this part of life partnership. There is no automatic right to inherit your estate in terms of succession law, even if you have been living together for many years. There is this myth that is going around that says that if you've lived with somebody for so and so years, the state declares them as husband and wife. That doesn't apply in South Africa. I believe you watch too many American movies, maybe that it applies in America, because I've heard of that 7 years that you guys are in some states, you guys are husband and wife. But in South Africa, in order for you to be a husband and wife, remember one of the requirements is consent. The state cannot make you guys married because you are living together, because there needs to be consent. That is a very important part. So if there's no consent, you guys can't get married. So that doesn't exist, right? If you have a girlfriend or a boyfriend, you guys are keeping fat and set, whatever you want to call it, cohabiting. The best way to protect each other is through a universal partnership agreement. Yes, it is a contract between a boyfriend and a girlfriend. That simply says, I've chosen this person as my life partner. I'm not going to marry them, but I want to note it down that this person indeed is my partner. Right? We share a business together, so and so and so. You solidify that through a will as well, saying that should I die, I leave this to them. Right? So it's very important to have a express universal partnership agreement. You need to have it. Write it down, sign it. Have witnesses as well. Right? So it's very important to do that. A will is critical as well, like I mentioned now. You need to have a will to solidify your partnership. Right? So without a will, I'm going to explain what's going to happen in the coming chapter. Without a will, your estate will be distributed according to the Intestate Succession Act, which means the state gets to decide who gets what from your estate. That brother that you haven't spoken to in years, if you have no children, when you die, everything goes to your brother, even though you hate their guts. You know? So essentially, the will gives you the freedom to decide what happens to your estate. Does it make sense? Are we together still? Does anybody have questions? Are we still good? Good. Okay. Now, this is very important. Everybody should just pay attention now. What happens when somebody dies without a will? This means you die intestate. Right? You don't have a will. I'm going to explain how the estate gets distributed when you don't have a will. When you don't have a will, the will gets distributed according to the Intestate Succession Act 81 of 1987. This act will dictate on how your estate will be distributed when you don't have a will. When you marry in community or property when you don't have a will, it's similar to, not necessarily similar, but when you get married in community or property, it's a similar situation. 50% of the wife, 50% of the husband. Right? But now when you don't have a will, it gets very complicated because the 50% of the spouse who is deceased gets distributed according to the Intestate Succession Act. And what it says is that if the estate is less than 250,000 rand, if the estate is less than 250,000 rand, the surviving spouse gets everything. The children get nothing. Does it make sense? And this goes back to was Tebogo. This is the downfall of not having a will. Your children might not get anything. They don't automatically get your estate when you pass away without a will. Okay. When it's less than 250,000, the wife gets everything. Doesn't make sense. So now, what happens if, for instance, the deceased estate is worth 600,000? and perhaps you have passed away, you leave a your surviving spouse is your wife and 2 children. You leave 2 children behind. What's going to happen is that the surviving spouse is going to get their 50% automatically because it's in community of property, and the other 50% will be distributed as follows. The wife gets 250,000 or a child share, or whichever is more. You understand? I'm going to make a scenario now. 600,000, the deceased estate. You have 2 children. The surviving spouse will be included as a child. It's called a child share. So the 600,000, when you divide it into 3, each one is supposed to get 200,000. Right. Now, this is after the estate has been wound up, and after the creditors have taken everything. The amount that is left, that's what is going to be shared. So now, let's say 600,000 that is left, divided by 3, it's supposed to be 200,000 each. But the law of intestate succession says the wife gets 200,000 or a child share or whichever is more. So now the child share is 200,000, which is less than 250,000. So which means the wife will get 250,000 from the 600,000, which means the children will be left with 350,000 to split. Does it make sense? So that is what is going to happen. That's what's going to happen if you pass away without a will. That is the downfall of it, because the children are the ones that suffer the most. And in some instances, even if it's done through the Intestate Succession Act, the children don't get anything because perhaps the wives take everything and don't leave anything for the children. You understand? So it's very important that you write a will so that whatever it is that you want to happen will happen. Because if it's through the Intestate Succession Act, the people who you want to get certain things, maybe if you wanted your firstborn to get your car, they might not even get it because you don't have a will. Doesn't make sense. Does everybody understand what's the implication of dying without a will so far? Does everybody understand? Does anybody have any questions for me? No questions. Does everybody understand? We're good to go. Okay. Okay. When you pass away out of community of property without accrual, the same sort of situation happens. Essentially, what's yours is yours, what's mine is mine. The surviving spouse keeps their 50. The deceased estate gets distributed according to whoever their descendant is. So the wife is not entitled to their 50%. So the children will get the 50%. Okay. So if there are no children, what's going to happen is that the estate might get inherited by the sibling of the person who has passed away. Okay. The wife does not automatically get the 50% because it is out of community. Does everybody understand? So without accrual, there is no calculation here. So it's a split, and the descendants of the deceased partner or deceased spouse gets everything. So the children get everything. It doesn't make sense. Right? So what happens when somebody dies without a will? This is for the accrual. So it's the same, sort of the same thing with the accrual when somebody dies without a will, when they are married out of community or property. What's yours is yours, what's mine is mine. Only the growth of our estate during the time of our marriage, that's what gets split. Remember, I did the calculation, the 1 million minus the 200,000, giving 800,000, and the spouse with the lesser growth gets half of the difference. So once that has been split, then only does the estate get distributed according to the Intestate Succession Act when you do not have a will. Okay. So it gets split first, and then the 50% of the deceased spouse gets distributed according to the Intestate Succession Act. But in this case, unlike in community or property, the spouse does not get a child share because they do not have access. They do not have entitlement to the other spouse's 50. All right. So does everybody understand? Is everybody with me? Okay. So we move on. Okay, the same thing with the life partnership. When you do not have a will, you can be living with somebody for years, but if you do not have the will, the estate will be distributed according to the Intestate Succession Act. It's the way I've been describing. Okay. But in this case, if you have no children and you have a partner, whatever it is that you have will go to your sibling. If you do not have any siblings, it's going to go up to your parents. So just think of a family tree. Wherever you are, your descendants are the ones that are going to inherit. If you don't have any descendants, go further up your family tree. And if there are no siblings, go up again. But if you are living with a partner and you have children, everything that you have is going to go to your children. There's no uncle, there's no brother that's going to get entitlement. If there's a child, then the siblings won't get anything. They don't have entitlement to anything. Okay. So your partner will not automatically inherit anything from your estate. It's like I said before, protect yourself, utilize a universal partnership agreement, and make sure that you also have a will to solidify that partnership. Okay. So when you die without a will, you must understand that the state focuses on family first. It focuses on family. Hence, it goes down to your descendants. If you don't have descendants, it goes to the next person on your family tree. Okay. So, in a life partnership or cohabitation, there is a way for your partner to claim from the estate. For instance, if you have a child together, the partner can claim for maintenance for your children. You understand, for the children that you have with them. Now, there's also, I can't really say it's a new trend, but when it comes to pensions, we covered that, I think it was in the first part. Go back to the first part on YouTube. We covered it briefly. There are people who are now, for instance, if you are a girlfriend, you can now claim from a boyfriend's pension. And they do this through various means, whether they're claiming for maintenance or they're proving that this person before they died, I was depending on them. They were paying me 5,000 per month in their girlfriend allowances. That is what is being used now to be able to claim pension funds. So I always tell people, be careful. If by any chance you are a man, you are in a marriage, and you have a girlfriend on the side, rather give them cash or don't give them at all. Because if even if you wallet, if it gets traced back and it is proven that indeed you are giving this person a specific amount of money, they will claim from your pension to maintain that lifestyle because they were depending on you. You understand? That is what is being used now to claim from a partner's pension. That is the strategy that is being used. So I just want to open up your eyes to that, for you to be aware. So that when you are planning your estate, you understand that these are the types of risks that are there. Okay. So are there any questions for me? Before we move on. Any questions? Okay. Everybody's good today. All right. Means I'm doing a good job if nobody has any questions. Okay, administration of a deceased estate. This is what happens now after you've passed away. Whether it's with or without a will, your estate needs to be administered. So in other words, there needs to be an executor that's going to make sure that the will gets executed. Okay, we are actually going to get into detail with this one next week. Administration of the deceased estate. We're going to get into detail as to what exactly happens, who is what role they are playing, the requirements, and what happens when your estate gets administered with a will and without a will. We're going to get into those things next week. Okay, so whether you die with or without a will, your estate must go through an administration process, which is called winding up. Okay, under the supervision of the master of the high court. So every estate needs to go through this process so that it gets winded up, and whatever is left gets distributed to whoever it needs to be distributed to. Now, an executor is appointed to manage this process. That's what an executor does. Okay, they take control of the assets, they identify and notify creditors and debtors, they post in gazettes, they post in local newspapers, so the creditors could know that this person has passed away, and that they can go and try and claim from the estate of this person. Okay, they determine the estate solvency, so they take all the assets and they will be able to establish the value of the estate. Okay. Prepare liquidation distribution account, which details all assets, liabilities, and how remaining assets will be distributed. So that one is self-explanatory. That's what an executor does. They pay all debts, legacies, and inheritances. Once it is, the winding up is done, the executor is the one that pays, or if it's money, they pay the beneficiaries the money after everything is being wound up. Okay, they obtain the master's release to finalize the estate. That is the finishing parts once the estate is being wound up. And the process can be lengthy and complex, especially if there are disputes among beneficiaries. So the only way to stop the disputes, like I said before, is through a will. It's important to have a will. Right? It's important. A will ensure that there are no disputes. If there are disputes, the will will be contested in court. And if you have followed these instructions and the requirements are met, it's highly unlikely that it will be contested. The contestation will be successful. Any questions? Okay, let me move to this one. The executor, the role of the executor. Person appointed by the master of the high court to administer and wind up the deceased estates. When you have a will, you can appoint the executor through your will. So that's another thing you should bear in mind. Like I said before, they report the death to the master. They take control of the assets, advertise your passing to the debtors, put in the newspapers and the gazettes. They determine solvency and open an estate bank account. So this is the job of the executor. Okay. Liquidation and distribution. Liabilities, assets and liabilities, and beneficiary distributions. That's their job. They publish in the gazette, local newspaper as well, distribute assets after the master has confirmed. Once the winding up is complete, obtain release. That's basically what they do. So they need to have power of attorney. They need to have deed of transfer, no executor details, only references. Okay, and divesting clause targets the estate, not the executor. That's basically what the executor does. This is just the formal things. We'll get. This is just the basic things. We'll get into detail next week. I just wanted to touch upon it just a little bit. Okay, they get 3.5% of the gross value of the estate. Now the gross is before the deductions happen. Okay, now we'll get into the other one, but push that income and whatever in the coming week. And yeah, the gross is before the deductions happen. So that is how much they're going to get. That is the payment to the executor. So every time you write, when you write a will through a bank, 3.5% is already theirs. When you write it through a law firm and you appoint them as an executor, 3.5% belongs to them already. So that's basically what happens. We will get into those as well, the other things next week. Is there anybody with any questions so far? Do you have any questions? Do you guys understand the requirements of a will? What is a will? The benefits of a will as well. Do you guys understand all that? Is there anybody with a question before we close the presentation? I'm just going to wait 2 moments. Maybe some of you are typing, I don't know. There are no questions today. Okay, no, that's fine. So that's basically it. If anybody needs any legal assistance, we'll schedule a consultation. You can contact us on WhatsApp on this number, and you can also send us an email and we will be able to assist you.